Historically, patients with a mental illness had few rights. They were subjected to institutionalization, warehousing, and inhumane treatment. In the 1970s, the laws changed regarding involuntary commitment and patient rights began to be recognized. Now, patients getting treatment for mental health issues have all the same rights as others, except the right to leave the hospital if they are involuntarily committed. They have the right to refuse treatment, send and receive mail, to have or refuse visitors, and so forth. Restrictions have to have a verifiable, documented reason. Taking away belts, shoelaces, or scissors from a suicidal person, restricting visitors from an aggressive patient, supervising or restricting phone calls if a patient is making threatening calls are all examples of this. The American Psychiatric Association developed principles for provision of mental health and substance abuse treatment services. Many states, patient advocacy groups, and treatment centers have developed their own mental health patient bill of rights based on these principles. Most patients are admitted to the hospital on a voluntary basis. However, if a person is a danger to themselves or others, they may have to be involuntarily committed. Each state has laws to govern the process for a civil commitment, but they are all similar. Commitment means that the patient cannot leave the hospital when they want to. There are a few types of commitment in Indiana. An immediate detention, or ID, is typically done by the police when they pick a person up off the streets that's suspected to need psychiatric care. They can take them to the nearest appropriate facility for evaluation. An emergency detention, or ED, is a 72-hour hold. The person can be held for up to 72 hours to allow for a thorough psychiatric evaluation. They can be released if the psychiatrist feels they are no longer a danger to themselves or others, or the commitment can be converted. A temporary commitment is commitment for treatment for 90 days, at which point it can be reevaluated by the court. The patient can be committed to maintain their address with the court, take their medication, continue treatment, and abstain from alcohol. Regular commitment is renewed on a yearly basis by the court, and the requirements are similar to the temporary commitment. A patient in the hospital has the right to leave as long as they are not a danger to themselves or others. A voluntarily admitted patient can sign a request for release and leave the hospital AMA. If a voluntary patient wants to leave who is a danger to themselves or others, the psychiatrist can file for a commitment hearing and the patient will have to stay in the facility until the hearing can take place. Legally mandated outpatient treatment is a requirement that patients continue with treatment involuntarily after their release from the hospital. It can involve taking medications, attending therapy in groups, or keeping appointments with their doctor. 45 states have laws for some type of mandated outpatient program. The 5 states that don't are Connecticut, Maryland, Massachusetts, New Mexico, and Tennessee. Court-ordered outpatient treatment is most common among those with severe and persistent mental illness. The court has to be concerned with the rights of people to participate in activities they choose, while communities feel a need for protection against possibly dangerous people who don't take their medication and may become threats. A legal guardian is a person appointed by the court to assume responsibility for another. If a patient has a grave disability, is incompetent, or is unable to provide themselves with food, shelter, or clothing, or is unable to act in their own best interest, may have a guardian appointed for them. A guardian can give informed consent, write checks, and enter into contracts for the patient. For a nurse, this means calling the guardian to get permission for a new medication to be started, or to let them know about any restraint episodes. People have the right to be treated in the least restrictive environment that will meet their needs. This means that a person can't be hospitalized if their needs can be met in an outpatient program, and they can't be restrained or secluded unnecessarily. This idea was central to the deinstitutionalization movement and the move toward community-based care. Restraint is the direct application of physical force to a person without their permission to restrict their freedom of movement. Human restraint occurs when staff physically controls the patient. Mechanical restraints are devices fastened to curtail physical movement like hitting, kicking, biting, and so forth. Restraints can be fastened to a bed, or they may use an ERC, which is a restraint chair. Seclusion is the involuntary confinement of a person in a specially constructed, locked room with a window or a camera for direct visual monitoring. Seclusion decreases stimulation, protects others from the patient, prevents property destruction, and provides privacy for the patient. The goal of seclusion is to give the patient time to regain control of themselves. Short-term use of seclusion or restraints is only allowed when the patient is in immediate danger to themselves or others. Other methods of calming have to have been tried first, things like a one-to-one talk, redirection, medication, decreasing stimulation. They all have to have been tried and failed. Adult patients must have a face-to-face evaluation within an hour of the event and every 8 hours afterward. There must be a physician's order or a renewal of the order every 4 hours for adults. The nurse must assess the patient a minimum of every hour and document the assessment. They will be assessing things like skin condition, blood circulation, offering food, water, and bathroom, and the patient's readiness to discontinue the seclusion or restraint. Close supervision must be maintained on a one-to-one basis for the duration of restraints and for the first hour of seclusion. After the first hour of seclusion, monitoring can be done through video and audio. The patient must be informed of release criteria as soon as possible. Debriefing is required within 24 hours. Health Insurance Portability and Accountability Act of 1996 protects the privacy of personal health information. This is also known as HIPAA. Mandatory compliance took effect on April 14, 2003 for all healthcare providers. Both civil, which are fines, and criminal penalties, prison, exist for violations of HIPAA. This includes any information, whether oral, written, or electronic. Mental health and substance abuse records have additional protection under the privacy rules. An exception to the privacy rule is duty to warn. Mental health clinicians must warn identifiable third parties of threats made by a patient, even if they occur in a therapy session that would normally be a protected conversation. Laws vary from state to state, ranging from mandatory warning to state the clinician may warn. Some questions to ask yourself if you think duty to warn applies. Is the patient dangerous to others? Is the danger a result of mental illness? Is the danger serious? Does the patient have the means to carry out the threat? Is the threat targeting someone identifiable? And is the victim accessible? Please note that it does say that the threat has to target someone identifiable. There's a big difference in saying I'm going to kill my wife and saying I'm going to get them before they get me. Insanity has legal meaning but no medical definition. The argument that a person accused of a crime is not guilty because the person can't control their actions or can't understand the wrongness of the act is known as the M'Naghten rule. If a person meets the criteria, they may be found not guilty by reason of insanity. The public perception is that a person gets away with the crime and is free immediately afterward. In reality, the insanity defense is rarely used because the accused has to meet the criteria and they're usually not successful. A few states allow a verdict of guilty but insane, and 4 states, which are Idaho, Kansas, Montana, and Utah, have abolished the insanity defense. Ideally, this means that the person is held responsible for their behavior and can get psychiatric treatment. However, that doesn't always happen. Nurses are responsible for providing safe, competent, legal, and ethical care to their patients. Nurses are expected to meet standards of care, meaning the care they provide meets set expectations and is what any nurse would do in a similar situation. These standards of care are developed from professional standards, state nurse practice acts, federal agency regulations, agency policies and procedures, job descriptions, and civil and criminal laws. A tort is a wrongful act that results in an injury, loss, or damage. They may be intentional or unintentional. Unintentional torts are either negligence or malpractice. Negligence involves causing harm by failing to do what a reasonable and prudent person would do in a similar situation. Malpractice refers specifically to professionals like nurses. Patients and families can file a malpractice lawsuit in any case of injury, loss, or death. In order to win, the patient or family must prove 4 elements. First, duty, that a legally recognized relationship existed. A nurse has a duty to a patient. Breach of duty, that the nurse failed to conform to standards of care, meaning that the nurse did not act as a reasonable and prudent nurse would act in a similar situation. Injury or damage, the patient suffered some sort of injury, loss, or damage. And causation, the breach of duty was the direct cause of the injury, loss, or damage. Not all injury or harm to a patient can be prevented, nor do all injuries come from malpractice. The issues are when a patient's actions are predictable and therefore preventable, and whether or not the nurse carried out the appropriate assessment, interventions, and evaluation to meet the standard of care. An example is if we know a patient is a fall risk, did the nurse take the necessary precautions using the alarms and whatever else is available to them to try and prevent harm to the patient? Intentional torts are voluntary acts that cause harm to the patient. Examples are assault, battery, and false imprisonment. Assault. This is any action that causes a person to fear being touched in a way that is offensive, insulting, physically injurious without consent or authority, like threatening to restrain a patient or give them an injection for failure to cooperate. Battery. This is harmful or unwanted contact with the patient. Actual injury does not have to have occurred. It can be touching without consent or restraining unnecessarily. And false imprisonment. This is the unjustifiable detention of a patient. It's typically the inappropriate use of restraint or seclusion. There are 3 elements to proving liability for an intentional tort. It has to be a willful and voluntary act on the part of the nurse. The nurse has to have intended to bring about consequences or injury. And the act was a substantial factor in the injury or the consequence. Nurses can minimize the risk of a lawsuit through safe, competent nursing care. Ethics is a branch of philosophy that deals with values of human conduct related to the rightness and wrongness of actions, and to the goodness and badness of motives and ends of such actions. Utilitarianism is a theory that bases decisions on the greatest good for the greatest number, or what gives the biggest benefit for the most people. Deontology is a theory that says decisions should be based on whether or not an action is morally right, with no regard for the consequences. There are 6 principles of deontology. Autonomy. This refers to the person's right to self-determination and independence. Beneficence. This refers to a person's duty to benefit or to promote the good of others. Non-malfeasance. Do no harm either intentionally or unintentionally. Justice. Treating all people fairly and equally without regard for social or economic status, race, sex, marital status, religion, ethnicity, or cultural beliefs. Veracity. The duty to be honest and truthful. Fidelity. The obligation to honor commitments and contracts. These principles have meaning in healthcare. Nurses respect a patient's autonomy through patients' rights and informed consent, treating patients fairly, promoting health, being truthful when talking to your patients, and so forth. An ethical dilemma occurs when ethical principles conflict or when there is no clear course of action in a situation. Autonomy allows a patient to refuse medication or treatment. However, non-malfeasance, or do no harm, may take precedence in order to keep a patient or others safe. Many dilemmas in mental health involve the patient's right to self-determination and independence and concern for the public good. Models for ethical decision-making include gathering information, clarifying values, identifying options, identifying legal considerations and practical restraints, building consensus for the decision reached, and reviewing and analyzing the decision to determine what was learned. Everyone has their belief about what's right or wrong, good or bad. Being a nurse presumes a duty to patients and families to protect rights, be an advocate, and act in the patient's best interest, even if that is in conflict with your own values and beliefs. A nurse is obligated to engage in self-awareness by examining their own beliefs and values so they don't become confused with the patient's. For example, if a patient is grieving over the decision to have an abortion, the nurse needs to be able to provide support to the patient, even if they don't agree with abortion. If the nurse isn't able to do that, they need to talk to the other nurses and find someone who can meet the needs of that patient.